Hello.
Hi, Giles. How are you?
Doing good. How are you?
I'm doing all right. I just wanted to get y'all set up here, but it looks like you are rolling.
I think you need to make me the host, and hopefully the guy who's the moderator will join us at some point soon. It would be great if he was a co-host because it looks like it's doing great right now, but my internet was really unstable earlier, so it'd be good to have
No,
a
no problem.
redundancy.
So I just made you the host. You should be able to give the moderator host permissions as well once they're here.
Oh, perfect. Thank you.
Yeah, not a problem. Do you have any questions? Is there anything that you need on my end?
No, I if you want to ring off, that's fine.
Perfect. Okay. Yeah, I do need to hop for another thing here in just a minute, but I can hang out and just make sure everything's good with the moderator and such too for a few minutes.
Okay. Hey, Phil.
Hey, Giles.
My internet earlier was really unstable. It seems like it's greatly improved now, but anyway, now you should be a co-host. So.
How many folks did we end up with registered for this?
I did do a double check, so I think it was 13, and maybe it went up, but I expect it's gonna probably be something like that.
Are our other panelists intending on joining sometime soon?
I hope so.
Emily has texted me and said she will be on right before.
Okay.
Hi, Emily.
You're on mute.
Sorry, hopefully that'll be the last time you have to tell me that. Y'all doing okay?
Yeah, we're just missing Sam and Tim.
Yeah.
All
There's
right,
Sam.
Tim.
That's
Sam?
good. There's Sam. Okay.
Um,
All right. Now hopefully we have an audience too. Great. Tim, you're on mute.
Hey everybody.
Hey, Tim.
Hello.
Should I lose the headband?
I mean,
It's very, very American Patriot. I like it.
Well, this is for the Constitution Society, so I thought I'd look the part.
excellent. Since we have all of 2 participants at this point, I think maybe if we wait a couple minutes, hopefully we'll have a couple more folks join us.
Those of you participants that are on the meeting, we are just giving it a couple minutes in hopes that we have a few more folks join us, but we should be getting started soon. So just sit tight.
All right, so maybe wait 1 more minute. Does that sound good?
Sure.
Longer? 2 more? All right, maybe we should get started and hopefully more folks will join us, but does that sound good to y'all? Yeah, okay. All right. Wonderful. Well, hello and welcome. My name is Giles Rodenheiser. I'm a member of the board of this, the at-large chapter of the American Constitution Society. Thank you so much for taking the time to join us today for this exciting event, which we've entitled Courtroom Successes During the COVID-19 Crisis, Constitutional Victories in a Time of Pandemic. Our moderator today is Phil Dixon, Jr., who is a defender educator at the University of North Carolina School of Government. One of our participants today, unfortunately, is in trial, a trial that went over longer than was expected, and Phil will actually be serving in a dual role of taking the place of Ian Mance, a staff attorney at Emancipate, North Carolina, while also moderating, because he is a speaker extraordinaire. Also, we have Sam Weiss, who is the founder and executive director of a nonprofit organization called Rights Behind Bars. Emily Coward, who is a project attorney also at the University of North Carolina School of Government with the Racial Equity Network project there at the school. Also joining us is Tim Henderson, who is a public defender in Asheville, North Carolina, which is Buncombe County Defender District 28. So thank you so much again for joining us today. The discussion today is really meant to be a discussion, so y'all are all automatically on mute at the beginning, but please do feel free to engage either in the chat or by unmuting yourself if you do want to speak. We have a small enough group here today that if folks are interested and have something that they want to share with the group, there's nothing to prevent us from having a conversation here. So with that said, I think, and our moderator will try to rein you in if you're interrupting folks too much, and I will try to do that too. I guess I'll pass the baton over to Phil, and he'll get us started with Ian's material and to introduce the other panelists maybe a little bit more fully than I have.
Yeah, thank you, Giles. As Giles said, I work with the School of Government at UNC, and I mostly train public defense people, private and public defenders, but also others in the judicial system. And the UNC government is a great resource. Certainly, Ian actually has been at the heart of a lot of our efforts in trying to figure out the implications of the pandemic on the criminal justice system. So throughout the chat as we go, I will try to put in links to relevant materials, and we will hopefully impart some useful information to everyone. Like Giles said, again, please feel free to jump in and interrupt us. It's a very small group, and the benefit of that is that we can talk. So feel free to jump in at any time. I'd actually like to start with Sam, if that's okay, Sam. And you heard that Sam is the director and founder of Rights Behind Bars. He's also been a civil rights litigator for quite some time, working with the ACLU, the Southern Poverty Law Center, and other organizations. Sam, you had a great success in the 10th Circuit in regards to ICE detainees. Can you tell us a little bit about that?
Sure. So we had a case led with several other wonderful co-counsel groups, but led in part by my colleague at Rights Behind Bars, Oren Nimni, suing the Bristol County Detention Center in Massachusetts. This is sort of a notorious facility that Warren already had a couple of cases against, both on the criminal side and the immigration detention side. And it was sort of an unusual tactics. This was early on in the pandemic, where people who were bringing in conditions of confinement claims were mostly doing so seeking changes in conditions, and mostly doing so not necessarily class-wide for all incarcerated people, whether in prisons, jails, or immigration detention centers, but for a small subclass or for individuals with really extreme medical vulnerabilities. And what Warren and the group did was they brought a case, a class habeas case, seeking habeas for all 148 people in the Bristol County Detention Center. And they were helped somewhat by the fact that, this is sort of a notorious facility. Conditions across the board are really awful, and the evidence made clear that these people were being left very vulnerable to COVID. I also think it has there's a big doctrinal difference between civil detainees and post-conviction detainees, but much less so between pretrial detainees. But there is, I think, a pretty significant atmospheric difference where people who are not being held for a crime, but solely because of their immigration status. So what the judge did was he did grant a provisional class certification and did grant a part of a preliminary injunction against part of the conditions. What he decided to do was to reevaluate everybody's bail claim individually. And so the government and our coalition were litigating the bail status of the individuals one by one. And over time, sort of really long story short, the population got down in the facility from a population of 148 to a population of 7. That has now ended with a settlement where at first, a lot of the bickering was about the people let out were let out with very onerous bail conditions. And after some bickering, they're now let out with no bail conditions and can only be re-detained if they're arrested for a new offense. So we think this was a big victory. There were a lot of other cases around the country that some of which had similar success and a lot of which unfortunately did not. And a big part of that was that the immigration cases had more success than the jail cases. Part of that being that the immigration detention centers are not subject to the Prison Litigation Reform Act. And so the Prison Litigation Reform Act has an exception for remedies that are, the exhaustion requirement, I should say, has an exception for remedies that aren't available. And people like me have long argued that in emergencies, the administrative remedies are not available. And this is a prime case of that. But and you'd think this would be a really good opportunity to establish that broader principle, but that's not how things shook out. And there were a couple of prominent federal appellate decisions that stayed or reversed district court injunctions on the basis that remedies hadn't been exhausted. And again, it takes several months often to exhaust administrative remedies. This is an emergency, it's a global pandemic. You'd think maybe this would be an opportunity to establish the other principle, but that's not how things shook out. And then I think another reason was that the district court judges who were seeing up close what was happening, even ones like our judge, who was not a Democrat, were more amenable to the plaintiff's claims than the federal appellate courts. However, because of the somewhat unique procedure that our judge did, which was to evaluate bail claims one by one, it left, it was just generally harder to appeal. So there's actually an open question in the First Circuit over whether there even is appellate jurisdiction over bail determinations in immigration cases. But even if there is, it's not the sort of sweeping injunctions that did get reversed in the Fifth Circuit in a case called Valentine, and in the 11th Circuit in a case about the jail in Miami-Dade County. So overall, I think, our case, we're pleased how it shook out. 7 isn't as good as 0, but and
A lot better than 100 and some, right?
a lot better than 148. But it's also a demonstration of, I think, for a couple of doctrinal reasons and a couple of atmospheric reasons, the immigration detention cases ended up having more success than the prison and jail cases. And then, and I should say that the people who were incarcerated in the detention centers did a lot of organizing themselves, a lot of self-advocacy. And in fact, there was an uprising that shut down one of the wings in May 2020 out of outrage that, and the Bristol County Sheriff responded with extreme force. There's been now an investigation from the Massachusetts State Legislature and the Massachusetts Attorney General saying that the constitutional rights of the detainees were violated in the response to this. So they obviously, the affected individuals themselves really did a lot of leadership and organizing around these issues and are largely responsible for the success of the case. And to pivot very briefly, I'll just talk about one other kind of work that we do, because we mostly practice in the federal courts, and the rest of the conversation will be mostly about state courts, which is that one other sort of success story from the pandemic is the compassionate release provision in the First Step Act, which was passed several years ago, and basically says that if you have an extraordinary and compelling circumstance, you can be resentenced under re-examining the sentencing factors. And the extraordinary and compelling circumstance that was most common and most anticipated, I think, in passing the provision was people who are very, very sick and on their deathbed. However, for at least people with medical vulnerabilities, they were able to make the argument that the fact that COVID was running rampant in their facilities was an extraordinary and compelling circumstance that should allow them to be resentenced. And the last I checked the numbers, over 1,000 people have been released in the federal system, which is, a system of a couple 100,000. So, a non-trivial amount. And there was a very major system, very major coordination effort underway, led mostly by local federal public defenders to represent people and put together these compassionate release petitions. There wasn't we handled a couple of cases on appeal in the federal appellate courts. There's not a ton of law here. It's a pretty discretionary judgment. However, there were some legal issues that come up out of it. Again, actually largely on the exhaustion question, like what exactly people were obligated to do. And there are sort of complications and splits on that. But ultimately, if you get to the weighing of the sentencing factors, you're sort of stuck with the district court judges that you have and how they evaluate whether you deserve to be in a COVID-infested prison or not. So with that, at the end, I'm happy to take any questions, but I'm also happy to hand the reins over.
Well, so just in terms of the legal framework here, right? If we're litigating conditions of confinement for prisoners normally, then we're talking about Eighth Amendment claims, cruel and unusual punishment. That doesn't apply to the civil detainees, correct? Right,
that's exactly right. So this is an issue that came up a lot in the jail cases and in the immigration detention cases, which is there's an equivalent of under the due process clause. It's often been treated until very recently as exactly as the same as the Eighth Amendment standard, the sort of deliberate indifference to a serious medical need or a risk of harm in other ways. There was a 2015 Supreme Court case called Kingsley versus Hendrickson that shattered that assumption a little bit, that those were always going to operate in parallel. And so what we had here are these sort of two tracks, which are one, the Eighth Amendment standard, or in certain circuits, sort of Eighth Amendment light after Kingsley versus Hendrickson. But then there's this other distinct standard, which is that arising out of a 1979 case called Bell versus Wolfish, which says that pretrial detainees and, of course, immigration detainees cannot be punished at all. It's not just that they cannot be cruel and unusually punished, they can't be punished at all. And so the question of what standard applied exactly, was it this deliberate indifference standard or deliberate indifference light, or was it a punishment standard where conditions are harsh enough that they amount to punishment? And are these standards actually different? Do they both apply? Is the deliberate indifference or the deliberate indifference light standard out of Kingsley just a flushing out of the punishment standard. That's something that ran throughout these cases, but in Savino specifically, the argument was that the conditions were so harsh that they amounted to punishment and therefore violated the due process clause. And since we're in federal immigration detention, that's Fifth Amendment due process instead of 14th Amendment.
Thank you, Sam. And so I've put the link to the Savino case in the chat if you're interested in reading it. And Sam, just a couple of final points. My understanding is even before this litigation was really fully formed and litigated, you began getting people out on bail right away, basically. Is that right?
Yeah, that's we were able to get out a number of people fairly quickly, and then and also a big success was that we were able to get a preliminary injunction that prevented them from adding new people to the facility, and so they couldn't.
And other things, right? I mean, testing everybody,
Yeah.
Isolation measures, contact tracing, and special monitoring for the vulnerable.
Right, exactly. So some of those conditions of confinement type claims as opposed to just release, but still, and there's some tension there because we're arguing that the very, and the reason this is being brought in habeas, right, is because we're arguing that the very fact of their detention is illegal, while simultaneously arguing that their detention needs to be made better. And the former argument is really relying on the idea that there's no way it can be made so much better that it won't amount to punishment. So these goals are in tension, but ultimately we're trying to keep the people who are in there as safe as we possibly can while trying to get as many people out. And so, that's a bit of a tightrope walk.
Oh, thank you, Sam. For those of y'all just joining us, Sam Weiss is with Rights Behind Bars, and he was sharing his story of success in the First Circuit in getting a preliminary injunction and the release of a lot of ICE detainees. He also talked about using the statutory mechanism of compassionate release in federal court, and basically where you have a person sick with COVID or a person very vulnerable to COVID, shoehorning that into the compassionate release scheme. And Sam had some success with that. So thank you for sharing. And again, participants, y'all, please feel free to speak up or jump in or put something in the chat if you like. This would be the point at which we would turn to Ian Mance and talk about his efforts in North Carolina. But as you heard at the beginning, Ian started a trial Monday that was supposed to finish Wednesday. It is still going, and he is not able to join us. So I'm going to do my best to at least briefly talk about the things that he and others in our state have accomplished. So we're all based in North Carolina. Ian at the time, or Ian has previously been with us for almost all of the pandemic as our COVID research attorney. And he has been just prolific in terms of the amount of stuff he's produced. It has been a team effort somewhat, but I'm putting in the chat right now a link to our COVID-19 toolbox for attorneys. And I'd first just draw your attention to that. I mean, while this stuff is somewhat North Carolina specific, many of these COVID papers are addressing federal constitutional claims and sort of logistical problems of dealing with trials and hearings and all aspects of criminal cases in COVID times. There is a paper on masks and jurors and witnesses, access to counsel issues where the attorneys are being kept out of the jail because the jail is closed or shut down and they don't have video link operations up. There's a paper on pretrial release and litigating COVID, another on sentencing, another several on jury selection and jury management during these times. So you have that link, and that's I'd encourage you to check that work out. In terms of successes we've had in the state, a really notable one, and I think one that tracks a lot with the kind of stuff Sam was just talking about, was NAACP and Emancipate North Carolina, a nonprofit here that works on behalf of incarcerated peoples. They sued our Department of Public Safety that runs our prison system, seeking equitable relief, asking for a preliminary injunction, seeking all kinds of things. I mean, the arguments, I think, largely were that it's not safe, and the prisons. The prisons are not doing enough. It's differing. There's different conditions in terms of a COVID response from prison to prison. And we have a program where people can be released to home confinement. That was not used very much prior to COVID. And then when the pandemic hit, there was indications from the state that, yeah, okay, we'll think about this compassionate release program, but it didn't really happen, at least certainly not on any kind of systemic level. So in that lawsuit, a Wake County judge issued a preliminary injunction and ordered the Department of Public Safety to expand the category of inmates that could be released into home confinement. They ordered the prison system to come up with new ways for inmates to earn gain time and credit time, basically good behavior, knocks your sentence down to the minimum. They were ordered to expand that. They were ordered to stop all transfers into the facility, at least without some measures in place to require isolation and prevent the spread of the virus. The prison system was ordered to test all inmates in the system. And they were ordered to come up with uniform policies from prison to prison. So really impactful, I think great stuff. I have no doubt that saved the lives of some people that were in prison. And on a personal note, I think it's quite sad that it had to be accomplished that way, but such as it is. Ian was also heavily involved in a case called State v. Dahl. It actually was decided, I think, this Tuesday, this past week, and I'll put a link to that in the chat as well. And Dahl and several other cases were habeas actions brought in state court under state habeas law, effectively alleging, much like Sam's case, except with the 8th Amendment focus, cruel and unusual punishment and deliberate indifference on behalf of the prison officials towards those incarcerated. This mechanism, state habeas, became really effective for prisoners in our state, and if not getting their conditions changed, if not getting them out, it got their conditions improved somewhat. And Dahl, the decision that just came down, on which Ian worked closely, that cleared up a significant issue in our state habeas law. We have a provision that basically says, if you're confined in prison as a result of a lawful judgment, you're not entitled to habeas relief. Another part of our habeas law, though, says even if you're lawfully imprisoned, if conditions have changed such that it's now unlawful, you may seek habeas. So we had these two conflicting provisions, and the state argued hard, tooth and nail, till the bitter end that inmates lawfully confined pursuant to a lawful criminal judgment were simply not able to seek habeas relief whatsoever. They were not eligible to file, and summary denial of these petitions was appropriate in all cases. Thankfully, that our Court of Appeals just disagreed. They issued an exhaustive opinion reviewing the history and evolution of the Great Writ, and sided with the plaintiff, or the defendant, insofar as he has an ability to pursue the claim. They ultimately denied the petition that Mr. Dahl filed on the grounds that he failed to provide expert evidence of the link between his claimed condition and his claimed increased risk of infection from COVID. So while that is, partly a win and partly a loss, it helps us clarify the nature of these state habeas claims. And it also gives all the other inmates out there that are seeking habeas in North Carolina a little bit more to go on. We know now that you saying, hey, I have asthma and I'm at risk, is not going to be enough. You likely need to provide an expert affidavit attached to your habeas petition. That said, though, this lawsuit still, Mr. Dahl was released 6 days after the hearing on this case to home confinement. So while his petition ultimately was unsuccessful, we learned a lot about, we made effectively good law, and did actually accomplish his release, although not quite the way we expected. And this is the pattern that we've seen. Ian and folks on my team at the School of Government have worked closely with a lot of attorneys seeking habeas relief and in the state. And that's often what would happen is we would get to hearing and the state would fold that day and agree to release the person to home confinement. I'm not sure if that was a calculated effort to avoid creating precedent, or maybe they found their compassion at the last moment. And I don't have hard and fast numbers, but I know that many people have been released as a result of this mechanism. I know that many more petitions are pending. Some are pending in the appellate division right now, and some are much better. There's a much better record set up than Mr. Dahl had. So I think I'm happy to report those are some successes. We did manage to get some people out. I'm not an expert on habeas laws of other states, but my sense is that the right to habeas corpus is enshrined in most if not all state constitutions, and or at least you have some sort of statutory mechanism for it. And so if people have not thought about that as a potential avenue, I encourage you to do so. I mean, hopefully now we're at the end of the pandemic, but for this and any other emergency or conditions claim, I think that's a viable tool to think about in addition to any federal remedies that you might have. With that, I'd like to turn to our next two panelists, Emily Coward and Tim Henderson. We are shifting gears. We've been talking about release of inmates or detainees and conditions of confinement. Emily and Tim will talk about jury selection issues. I'll start with Emily as our sort of resident legal expert in this area. Emily has been working in racial justice issues for a long time for the School of Government. She started with Batson claims, which North Carolina has one of if not the worst records on in the state as far as ruling for a defendant on Batson v. Kentucky peremptory strike challenges. But that eventually led Emily to get more interested in fair cross-section and how the whole veneer is created. And this became a serious problem during COVID because even when judges were trying to have trials, it was hard to get enough veneer people into the room, or when you did fill a veneer, it was also often slanted in terms of the demographics represented versus those in the community. So we're going to take the rest of our time and have Emily talk a little bit about the legal framework for fair cross-section and any other claims you want to talk about, Emily, and then we'll turn to Tim to wrap up to talk about his success or his efforts in litigating this in actual criminal cases in Buncombe County. So Emily, do you want to share some basic framework of fair cross-section or anything else?
I'd be happy to. Thanks so much, Phil, for setting that up. And obviously, when we think about jury trials resuming in the middle of a international pandemic, whether or not you have a fair cross-section of the community represented in the jury pool is just one of a number of issues that are going to be confronting courts. But we don't really have time to talk about all of them. So I do want to focus on that one because it tends to be one that attorneys have a little bit less experience litigating. It's actually quite labor intensive to do all of the research that you need to do to even find out if you have a meritorious fair cross-section claim. So I just want to spend a little time making sure folks are aware of the fair cross-section guarantee and thinking about how it is coming into play in this moment. As Phil mentioned, I began looking into this question when I was working on co-authoring a manual that we published called Raising Issues of Race in North Carolina Criminal Cases. I just put a link in the chat to that manual. And after publishing that manual, we started doing trainings for attorneys based on the content of the manual. And fair cross-section, again, is just one of the topics that we do trainings on. This link that I'm putting in the chat is a collection of materials that we've put together on fair cross-section for attorneys. Some of them are pretty North Carolina focused, but this law tends to be pretty, it doesn't vary much state to state. And of course, there's federal fair cross-section guarantee that's going to be the same, primarily the same. It might be interpreted a little bit differently circuit to circuit, but these are some resources for you to dig into, because I'm only going to kind of cover the bare bones of fair cross-section today. But I think in the advertisement that went around for this discussion, the question that was presented was whether pandemic era jury pools represent a fair cross-section of the community, and if not, what can you do about it? And of course, there have been big concerns before the pandemic that jury pools underrepresented people of color in this country. And those are only exacerbated by the pandemic. The National Center for State Courts did a study where they surveyed people as to their willingness to show up for jury service during the COVID-19 pandemic. Young Black and Latinx women and older white women were the least likely, the most hesitant to appear in court in response to a jury summons, while younger white politically conservative males were the most likely to be willing to show up for jury service. So all of the different factors that created underrepresentation in jury pools before the pandemic are certainly exacerbated by the way that the pandemic is affecting who is comfortable showing up for jury service, who is available to show up for jury service, who's an essential worker, who is home taking care of children doing virtual school. These burdens are not equally distributed, and so they're going to affect who can show up and serve on a jury. So just to kind of step back a minute and make sure that we're all on the same page about what the fair cross-section right guarantees. It derives from the Sixth Amendment guarantee of an impartial jury. The U.S. Supreme Court has held that an essential component of that impartial jury guarantee is a selection of a jury from a representative fair cross-section of the community. And states all have parallel provisions in their own constitutions that you're probably aware of. And why is it so important that this guarantee exists? Well, we know from the research that diverse juries deliberate longer, discuss more of the facts of the case, make fewer errors, bring up more questions about what was missing, are more likely to bring up sensitive topics like race and bias, and are more likely to acquit. The jury is, of course, the voice of the community, and we all have a right to serve on a jury if we are eligible citizens. And overly white juries really erode public trust and the legitimacy of the whole judicial system. So if you're looking at whether or not you have a problem in your county, you may have statistical evidence or just anecdotal impressions that your jury pools are not representative of your community, but you need to be able to show three things to make out a claim. You need to show that a distinctive group is not fairly representative when compared to the number of those people in the community, and that underrepresentation, this is the third prong, is due to systematic exclusion. And so courts have mostly said that the distinctive group is groups defined by race, ethnicity, or gender. Underrepresentation, there's no minimum threshold, and any measurement, as long as it's any measurement will be considered by the courts. There is no sort of gold standard of how to measure underrepresentation. And systematic exclusion, this is sort of the most important thing to keep in mind about fair cross-section, does not mean discrimination. It does not mean a bad actor or intentional animus creating unrepresentative jury pools. It just means something inherent in the process, a flaw in the process that is creating underrepresentation. So a classic example of that is a federal district court in Connecticut had a software program where they were reading the D in Hartford as they were carrying it over to the next column and reading it as deceased. So everybody in Hartford was treated as deceased for years. And the majority of the Black and Latinx population in that district lived in Hartford. So that was producing underrepresentation, not because of any intentional discrimination, but because of a software error. That's systematic exclusion for purposes of fair cross-section. You shift the burden to the state if you make out all three elements, and they have to show that a significant state interest is manifestly and primarily advanced by those aspects of the jury selection process that result in the disproportionate exclusion of the distinctive group. So this is the problem for fair cross-section, is that, you know, trying to keep people safe in a pandemic is a significant state interest. And courts that have confronted this so far have found that that's usually where you run into problems with the fair cross-section. But I guess I just want to encourage you to consider pushing on fair cross-section anyway, because there can be a lot of things that can come out of looking at this question, whether or not you ultimately succeed on the merits, which you may. I mean, I think you have strong arguments to actually be able to prevail, but it's challenging, and I won't lie and say it's not an uphill battle. This is a time when courts are creating new jury resumption plans, and they're having to make adjustments, and we need some sunlight on that process. We need to understand, how are they reviewing requests for excusals? How are they trying to bring in enough jurors to serve, and making sure that they're not making adjustments in a way that exacerbates disparities and creates really white juries is in everybody's interest. So if you seek discovery on fair cross-section, which is critical to do, because obviously fair cross-section applies to the invisible stage of jury formation. If you seek discovery, you're going to get a lot of information that's going to be of interest to the community and to court actors who are concerned about making sure we have diverse representative juries. You may get a delay that is really helpful in your case. You may cause the court to think about steps that they could take that they should be taking anyway to ensure that we have diverse juries, like making sure you have representative source lists, like doing follow-up mailers to make sure that you are actually reaching the people that you're trying to reach. There's a lot of sort of best practices that are not implemented in many courts. And by raising this issue, you can encourage the courts where you practice to really be proactive about trying to create diverse jury pools and making sure that, you know, the folks that they're bringing in fairly and, you know, accurately are representative of the community. You don't need to be a member of the distinctive group to raise the claim in terms of standing. You do need to seek discovery, and whether or not you have a statutory right to discovery, as you do in some states, all of the state Supreme Courts who have considered this issue have found that the right to discovery is inherent in the constitutional right. So don't let that stop you. There's a lot of materials. Again, I will put some more in the chat after I turn it over to Tim that can help you get started in looking into whether or not you might have a fair cross-section claim in your case. I won't go too much more into the weeds, but happy to answer questions. And again, I'm going to put a few more materials in the chat. This is a great time to be looking at fair cross-section, because I do think the pandemic is distorting jury pools beyond what they were. You know, they were already sort of in, I think, an under-examined state where people just assumed that we had processes that were creating accurate, fair, representative, inclusive jury pools. And if you saw litigation around race and disparities in jury selection, it was usually focused on Batson and on peremptory strikes. But I really want to encourage you to look at the list, look at the process, and take a look at some of these fair cross-section materials, because even if you don't prevail on the merits, there may be benefits to your client and to your community that can come from going down this road. And Tim can talk a little bit more about that.
Thank you, Emily. Just to tie off a couple of quick things, I meant to mention that Emily is co-author of the race manual. She put that link in at the start of her chat. I strongly encourage everyone to check that out, regardless of where you are. You know, it is mostly based in, most of what they're talking about is federal constitutional law, and there's stuff about like equal protection challenges to police action, along with, you know, detailed stuff about fair cross-section and other aspects of sort of, you know, lesser used but still potent constitutional claims that can be made. So thank you for your work there, Emily, and I encourage you all to check it out. The federal claim here is really based in Duran. Is that the name of the case, Emily? Duran claims. And you mentioned, I think you alluded to it, but just by raising this issue and requesting discovery on the jury selection or the jury formation process, you are entitled to that discovery. I mean, period, right? And this is because it's voluminous, that's almost certainly going to buy you time. And finally, I just wanted to note that, you know, your work in this area has, whether there's been litigation or not, some of this has led to buy-in from county actors saying, we want to take a hard look at our jury formation. We want to make sure it's more fair. This has led to actual policy changes on the ground, even outside of the litigation context. Is that right, Emily?
Well, certainly it's led to movement in that direction. The governor's task force in North Carolina has adopted recommendations for adding additional source lists and some other modifications that would try to ensure more diverse jury pools. And there's a study that I think Tim's going to mention that has been proposed to kind of take a deeper dive into these questions. And so, yes, I think, and there are counties in North Carolina that are now collecting this data that didn't used to. The DMV is including more information when they provide the data to the counties. So it's kind of slow going, but it is moving in a direction that it has not been in the past. And I think we're going to see some of these cases because they've been well preserved. The issue's been well preserved in a few cases. I think we might also get some more enlightened legal doctrine on fair cross section in North Carolina than we've had in the past. And so, you know, we're kind of, people are going at it from a number of different angles, and I would say that there is movement on all fronts.
Well, thank you, Emily. With that, let's turn to our final panelist, Tim Henderson, who's an assistant public defender in Buncombe. That's in Asheville, North Carolina. Tim, tell us about your experience, and you were first up on the jury resumption plan. Is that correct?
That's right. I guess I came to the fair cross-section issue and my interest in it originally as primarily a matter of self-preservation. North Carolina shut down all jury trials in, I guess, middle March 2020, and there were rumblings throughout the summer that at some point those would resume. And I guess in October, they got rid of the pause and said, okay, you guys, your judicial jurisdictions can start to make a plan. And so people did, and there was kind of a race across the state to see who would go first and who was hanging back. And, you know, the plans were made in like August and September, but by the end of October, the numbers for COVID were starting to climb higher and higher. We were set to start back in first or second week of November. A lot of counties kind of backed down, but here in Buncombe County, we are a rugged mountain people who will do as we see fit, regardless of outside elements and things like that. So they decided to go forward with jury trials, but they didn't want to do really serious or long and in-depth trials, which meant that they were looking for short 1 or 2 day trials. I promised I wasn't going to swear during this conference, so I will not refer to my cases as chicken shit misdemeanor appeals. But that is what they were. And for the first week's resumption calendar, I think I had 3 or 4 cases out of 10, and it became pretty quick that the other 6 weren't going to go. So we were front and center for the debacle that was coming.
Tim, quickly, just in case anybody's not from North Carolina, we have a bifurcated system where misdemeanors are heard in district court by a judge only, but you have a right to de novo appeal in superior court in front of a jury. So that's the stage that Tim was at. Please.
Thanks, Phil. So, you know, none of my clients were in custody. We weren't making speedy trial motions. We weren't really quite sure what to do, but it didn't really seem safe to anyone involved, our clients, the jurors, other court actors. So we filed a motion based on public health reasons, but also various constitutional grounds that these conditions would violate any number of constitutional rights. The one that got us the most traction was the fair cross-section issue. I've been working with Emily and Ian, and I think Phil, you consulted on it too. Basically, the whole School of Government was helping pump up our motion. The animating question on that motion was really just what sort of person would come to jury duty at the height of a pandemic? And we looked at our resumption jury plan policy, who was going to be summoned. And first they decided they would bring in half as many people as usual, but they would also liberally excuse practically anyone who asked, but especially the elderly or people dealing with childcare issues, or essential frontline workers, as broadly as you can define that term. And one of the things that I worried about for my clients was that the only people left to show up to the pool would be a bunch of, you know, mid-20 somethings who are presently unemployed and don't necessarily believe in science and are really angry about being cooped up in lockdown for so many months and want to punish somebody, probably my client. So we filed a motion for jury pool discovery. We used the Racial Equity Network's motion, which I think we've already put a link to their database in the chat. Consulting with Emily and with Hannah Autry from the Center for Death Penalty Litigation in Fayetteville. She's done a lot on this area as well. One of the things as I got into knowing it was how little I knew to begin with. I think the original motion we filed misidentified the source of our fair cross-section right as the 14th Amendment, when really it's the 6th Amendment. And again, the 6th Amendment is the magic part of this whole motion, because as was already mentioned, you don't have to make any sort of showing of bad intent or discriminatory outcomes. You don't have to be a member of a protected group or anything of that nature. And if you are denied a reasonable opportunity to investigate, courts have found that that's reversible error. So we're pretty pleased to have found that. We figured maybe this would buy us, you know, a little bit of time, and it'd also just be an interesting area to kind of focus on and help move the law forward. We built our motion off of the sample from the Racial Equity Network, emphasizing especially the third prong, which was the systematic basis, because the liberal granting of excuses, you know, the people in essential work groups, people with child care concerns, the elderly, people with pre-existing conditions, there could be significant overlap between those and distinct groups as so far identified, mostly women and people of color. So we filed that the Friday before we were supposed to start. The DA's office filed a reply accusing us of engaging in a fishing expedition and improperly impugning the integrity of our county's beloved jury clerk. And we thought we were probably cooked on that, so we were ready to go for trial. But lo and behold, morning of trial, we showed up and the judge, he bid into our motion and granted it and said we should get all that we were asking for, which was essentially, you know, a list of all the names of prospective jurors who were being summoned for this term, basically a record of any excuses requested, denied, or granted, whichever the case, as well as the DMV data, demographic data of pretty much the entire jury pool, or at least the folks who were summoned. In North Carolina, the jury pool consists of two sources. There's voter data from the Board of Elections, and that's publicly available. And then there's data from the DMV, which is a little bit more inclusive of the population as a whole, at least of those who are eligible for jury service. Not everyone who is eligible is registered to vote, so on and so forth. So we asked for all of that, and all of it was granted. The first thing that happened after that was we got hard copy of like a 10-page single-spaced document listing the names of 1,200 people who had been summoned for jury duty in the next 2 weeks. And we had to kind of break that down. As I said, the voter data is publicly available, so we started making an awful lot of spreadsheets, and kind of through trial and error, we're able to come up with a document that was somewhat searchable, somewhat functional, and held some of the key data, at least for distinctive groups. It took a while.
No small feat, right, Tim?
Sorry?
No small feat there, correct?
That's a lot. I mean, I'm not really good with computers. It's miraculous I'm speaking to you now, given how inept I am, but I had a co-counsel who is more savvy with that. I think she's a millennial. But so I learned a lot about spreadsheet making and so on and so forth. And at a certain point, we started consulting with a professor at UNC Political Science Department, Frank Baumgartner, who Emily had given us his info. We sort of cold called him and we're like, can you teach us about statistical analysis? And he took a look and said, well, you need to include all these other sources, all of which we could get through the voter data, but we didn't know what we were doing. So we started making the spreadsheets over again. Eventually we realized we could just pawn this job off onto a group of unsuspecting pro bono law student volunteers for a wonderful winter break project where they can advance social justice and get volunteer hours and spare us the toils of data entry. That helped a lot, and we started thinking about other ways to use the data that goes beyond just the distinctive groups, things that kind of line up with class issues. You know, one of the things the judge said when he granted our motion was, I've always wondered why we don't have anybody in our pool from public housing. And Frank Baumgartner started saying, well, hey, we can make geocoded maps of the addresses of people and the neighborhoods they're in, those that are getting summons, those that are showing up, those that aren't. I think Emily mentioned one of the reforms that the governor's task force is proposing is adding additional source lists. So it's not just people who can legally drive a car or vote, but also the public housing rolls to make sure, or to oversample those types of areas to make sure we're getting a diverse pool. The DMV data took a little bit longer for us to get. Our clerk of court tried to resist and obstruct and delay us from receiving it for as long as possible, but that really only helped to further bolster our continuance, which was just an ideal side effect from that. We eventually did get it. We may have been the first in the state to get a list of DMV race and demographic data. It had been rumored for a long time to exist, but I think they'd only recently changed it to where they would release it with a court order. All credit for that should go to Emily and Hannah Autry, because they're the ones that helped us figure out how to do that. And at the end of the day, we had a thumb drive with like 220,000 names on it. So we were then comparing those two data pools, able to actually precisely identify everybody who was in the jury pool. And we wanted to cross that with people that actually showed up. But after 2 months of our motions related, after 2 months of running the motion, only 4 days were their juries actually brought in, just because of all the public health stuff and various delays and continuances and so on and so forth. At the end of the day, we kind of got short-circuited in terms of our litigation, because the Chief Justice of the North Carolina Supreme Court declared basically a shutdown statewide of courthouses in late December, or I guess mid-December. So they paused the jury trials again, and we didn't really power back up here in Buncombe until middle of February, by which point we had numbers that were starting to decrease, which was good. And we also, working with Emily and Professor Baumgartner, had put together a research proposal to study this issue in a more systematic way over a longer period of time, which is what you really have to look at if you're trying to litigate a claim like this.
And you got buy-in from your Superior Court judge there, correct? I mean, the judge became interested, as you know, the court itself was interested in doing this, and if needed, reforming the system. Is that right?
Yeah, I think he was. He was the one that was always kind of frustrated by what we were doing, but he agreed with what we were doing. So I guess efficiency took a backseat to doing the right thing under the Constitution.
And ultimately you got what, like 3.5 month continuance?
All right, we were supposed to go November 9th, and we didn't go till February 23rd. So yeah, like 3.5 months. Since then, I've done 4 or 5 jury trials in 2 months. The jury pools that we've been getting, it's pretty random. You know, the fact of it is Buncombe County has a pretty low population in terms of diverse demographic groups. So when you're only bringing in 50 people, you only need 3 or 4 people to check all the boxes if we're just going by what's so far been identified. I don't know, this week I had a DWI trial where all 12 of the people initially seated in the pool were retirees. So it gets to be, I mean,
that's Asheville kind of.
Yeah, it is. We came in 2nd place, but that's still on the medals podium.
Tim, I don't want to interrupt, but I think we are getting to the close of our time. I know Emily has had to jump off just now, so thanks again, Emily. Any final remarks or conclusions, Tim, you'd like to say?
I just appreciate Giles for putting all this together. It's been a fun hour, and I can't wait to go to lunch.
Well, thanks to Giles and the American Constitution Society, as well as all of our participants. I hope you got something useful out of this. I'm sure that Giles can provide you our contact information. You could also find a School of Government people on the links that I sent earlier that are in your chat. I'm happy to open it up for any questions or concerns, or like I said, feel free to follow up with me or any of the speakers later. But if there aren't any concerns, then I'll turn it back over to you for any concluding remarks, Giles.
Well, thank you so much, Phil, and thank you to all of our panelists today. Thank you all for taking the time. My internet connection at the moment is unstable, so I may be. And thank everybody for their participation, for joining us. Yes, please do reach out to me if you'd like to get in touch with any of the panelists or you have any questions for them. I know that at least here in North Carolina, we're incredibly fortunate to have the School of Government as a resource, and some of their staff here today have volunteered their time, and I'm sure would be willing to help you too if you are interested in the areas that they're studying and the areas they're teaching in. So I think they're a resource to everyone, not just a lucky few here who happen to live in North Carolina. And these issues are national issues, obviously. So so again, thank you to everyone for participating, for your time, for your interest, and please do get in touch if you'd like to continue the conversation further. And otherwise, I hope everybody has a good rest of their Friday and a great weekend. And yeah, so thanks.